Welcome to Guardians of Innovation, Patent and Trademark Law.
Hi, everyone. Welcome back to Guardians of Innovation with Vincent LoTempio. Vincent is a registered patent attorney with over 25 years of experience helping inventors, entrepreneurs, and businesses protect and profit from their ideas. I'm Sean O'Connor, and today we're talking about real-world trademark cautionary tales, how everyday businesses lost rights, got forced into expensive rebrands, or ended up in lawsuits they never saw coming. Vincent, I'm looking forward to this one.
Hey, it's nice working with you. It's nice to see us, Sean.
Let's start with a case where the issue wasn't actually confusion or copying. It was the government saying the name itself shouldn't be allowed. And this is about the Asian American band called the Slants that tried to register their name, and the U.S. Patent and Trademark Office refused it. What happened? Why did this end up in? It went all the way to the Supreme Court, right?
Yeah, all the way to the Supreme Court, and it turned out to be more than just a trademark case, but a freedom of speech case.
Oh,
And they're giving themselves a derogatory name. And if everyone's familiar recently with all these sports teams, the
mhm,
Cleveland Indians and the Washington Redskins, and they all changed their names because they were derogatory towards a certain group of people. And that's and a lot of people said, why can we do this? The Redskins are a beloved team in the NFL that people have loved all these years. We're not trying to make it a negative thing. We love our team and we love our name of our team. And even Snyder, the owner of the team, refused to make the change, and he fought and fought until eventually
right.
now they're the Washington Commanders. But here's the opposite. The actual Asian American, or yeah, Asian American uh, band, wanted to call themselves this, and they wanted to register the trademark, and the trademark office refused them. And they ended up going all the way to the Supreme Court, like you said, and can imagine the cost of doing that and getting
Mm,
yourself that far and actually winning the case, which is quite remarkable. And then they toured afterwards into to a lot of these. We have to take what's called continuing legal education credits. We have to do them every year, and they actually showed up for one of my CLEs. And here's a picture. I'll hopefully have a picture to show you of me meeting one of the members of the band itself and going and speaking with them directly.
oh, that's pretty cool. Wow. So why exactly did the trademark office refuse it at first?
So basically, they're saying it's a disparagement.
Ah,
And there's a disparagement clause, in the patent office, that if you're going to use something of a disparaging or something against public policy, that you shouldn't get it. So because you can say that it's a disparaging name, the Slants. Every time, when we were growing up, I mean, I guess it's gonna um, tell. We already said I'm doing this for 26 years. You have an idea of how old I am, but call them Orientals, and I never thought there's anything wrong with that. In fact, I stayed in the hotel called the Mandarin Oriental, in Florida. But now it's called Asians, and and maybe when the Redskins, back then nobody looked at it as disparaging, and now Redskins are disparaging. So they're trying to protect the community as a large, and stop these types of names to be registered. But here's a group of young Asian Americans and Asians that wanted to call themselves Slants, and they weren't going to let them do it, and they fought it all the way to the Supreme Court, which is quite interesting.
I don't know if I just missed it, but what did the Supreme Court ultimately deny their finding?
No, they won. They won. They got to keep their name and they got it
Oh,
registered. So they actually won. And they said the Supreme Court ruled that this was a matter of freedom of speech, and they can call themselves anything they want to call themselves.
got it, got it.
So
Well,
so they actually won that case. But we always talk about winning the battle but losing the war.
right.
You go all the way through to the Supreme Court, even though you win that, you lose the war because it costs you tens of thousands of dollars of fighting it. And my suggestion in all these types of things when people come to me with names is don't poke the bear, right? And if you got to ask me, is this name too close to the Coca-Cola bottle or does it look too much like the Coca-Cola bottle? We already know the answer. Don't poke the bear. If you want to say, you really want to get really close to Adidas or or some big company, don't poke the bear. And that's what essentially they did here. But it turns out, probably they would have never gotten that type of recognition had they never done that. So, but do I want to advise you to pick a name that you're going to have to fight it all the way to the Supreme Court? Nah, probably not. You know.
Yeah, they were. In this case, they were. You mentioned Coca-Cola. You're poking the polar bear in that one.
Yeah, yeah, exactly. Yeah, like I said, if you have to call me and say, "Does this look too much like the Coca-Cola bottle?" You already know the answer. You already know the answer.
To say nothing about the dynamic ribbon device.
Yeah.
You touched on. I mean, just the sheer cost of the litigation. But are there other hidden costs from a business standpoint that people need to be aware of? I mean, obviously, there's just the expense of it all.
Yeah, I mean, to fight it. And we've done this episode before about, picking the correct name. And we talked about the 5 levels of distinctiveness and
Oh,
picking the right name the right way. And there's all different reasons why you'll get rejected, in the patent office. And when I see that you're going to fall under one of these categories of being rejected, I try to convince people to change the name. And that's always difficult because people are in love with their name and it's not easy to pick the new name. It's drug companies spend millions of dollars to come up with a drug name and it comes up with 6 letters and some weird name of Sembic or something, and they spend millions of dollars to finally decide on how to do it. So it's not an easy thing, but it's kind of like when we talked about the patents, starting with a good foundation and working your way up and not trying to fix, the roof in the basement afterwards. You make sure you put the roof on at the right time. And so picking that name, deciding on that name right from the beginning is the most important thing. And doing that search as early as you can to see if there's anything out there that's gonna, become a time bomb and blow up and later is the big key is starting early and working, spending a couple $100 with an attorney to do a search is much better than taking 75,000 labels off products and relabeling them later.
yeah, yeah.
And
The
that's a true story. That really happened. 75,000 cases of apple cider, and they came to me afterwards. It was like, we could have done the search and found out that this was going to be an infringement right from the beginning, but now we're trying to fix something afterwards.
Well, that I mean that ties right into what I'm thinking. If you're choosing a what you know is a boundary pushing or controversial name, what are the specific risks you'd want them to understand before they commit to that? Because obviously, right, it's a like you said in an earlier conversation, it's some of this is a poker game. There's you can be more aggressive with your bets.
Yeah, well, you go into battle, right? And you want to be ready for battle. You just don't go in unarmed and not ready. And I always say the trademark is like a sword and a shield, right? The
Mm.
sword is you cut them off below their knees and tell them stop using my trademark. And the shield is they can't tell you to stop using your own trademark. And you have that registration up front and that you have that strength. Now registration isn't 100% foolproof. There's a presumption of ownership that you own it, but there's always um, it's a rebuttable presumption, and there's always a chance that someone could say, "Look, I never registered it, but I've been using it way before you, and you stole it from me." And that could happen at any time. That can happen before you get the registration or after. Now, after you own your trademark register, the longer you own it and the longer you used it, the stronger your trademark becomes. And if you used it for 5 years after the registration, you can file what's known as a statement of incontestability, where nobody can contest it. Now, and that's not even foolproof because I'm sure the Washington Redskins had a statement of incontestability filed 100 years ago, And then, all of a sudden everybody thought it was a disparaging trademark, and they still lost their trademark. So there's never ever 100% guaranteed foolproof way, but there are certain steps that you get it to 98% or 99% protected versus 1%, where there's a good chance that they're going to sue you and they're going to get you. So you want to make sure you do a search, you do your research before and after, and you're continually looking to see who's using your trademark, and you want to protect those rights, and you want to be ready to defend. I always say you have to play Hansel and Gretel, leave breadcrumbs behind. Have
Mhm.
a folder that shows every place that you advertise it, how many people have seen it, how many people have driven by your billboard on the throughway, how many hits have you had on your website, how many products have you sold. Those are all evidence of strength of a trademark. The more you use it, the longer you use it, the stronger your trademark becomes.
Got it. The some of this, I mean, I think you kind of touched on it, but I'm curious about um, what a pre-launch consult might look like if I were considering a name that it might trigger objections. I think you touched on some of it. Are there other aspects to a pre-launch consult that people should be aware of?
Yeah, usually when I get somebody on the phone for the first time, and my wife says I'm a data dump. I don't shut up, and I say I give you a 15-minute free conversation, and then I look at the clock and we've been on the phone for an hour. And but one of the things that we want to do right from the start is just a plain knockout search. I always say, look, if you type it in and it's not there, well, it's a good start. We're looking for a
Yeah.
needle in the haystack. If we find the needle, we stop, we move forward, and let's change it. Right now we found it. And then, that's your first initial phone call. And then after you hire us, we go into the details of it. And, the rule for trademark isn't that it's identically the same. I always use this example. If you have crystal clear cleaners and you're doing it with all K's, and I do it with all C's, the trademark office is going to look at that and say it's a phonetic equivalent, and then it's going to be confusing to somebody else out there, and they're not going to give you the registration. So if we found that one with all K's or all C's and you're the other one, we would say right away, this is going to be a problem. Let's try to work this out and try to come up with another name. And it's always easier to pre-launch doing it than after you've had signs put up and you're into your marketing plans, and yet
Mhm.
you have all this money invested, and all of a sudden you got to rebrand. Rebranding is not a fun thing to do.
No, no, and I've got some experience with some of that, and this leads to something that is definitely directly adjacent. We're talking about the names and trademarking specific names and avoiding confusion, but I know that there's also the issue around uh, confusion the way a brand looks, right? Like the what's called trade dress, right? There's You were telling me about the a local shop called Donut Delight that used a color scheme that Duncan took exception to.
Yeah, exactly. So yeah, so the colors, were a big issue. Even though Dunkin' Delight doesn't sound anything like Dunkin', or Donut Delight doesn't sound anything like Dunkin' Donuts. The pink and orange color scheme looks the same. And I forget, I think it's Coming to America, the movie with Eddie Murphy,
Hmm.
where there's that like the father of his girlfriend had this McDougal's restaurant. And even though it didn't have the McDonald's name, it kind of sounded like it, but the whole restaurant looked exactly like a McDonald's. So trade dress, the way it looks, certainly could be a problem too. Just to and it kind of goes back to I said before, if you have to ask me, does this look too much like the Dunkin' Donut color scheme, or does this look too much like the Coca-Cola bottle, then you already know the answer. You want to avoid poking the bear. That's always my advice to the client. And then the bear is always this big corporate client like Dunkin' Donuts. And Dunkin' Donuts changed their name. It used to be Dunkin' Donuts, now it's just Dunkin'.
Hmm.
And again, we talk about the five different levels of distinctiveness. There's generic, descriptive, suggestive, arbitrary, and fanciful. Now, generic donuts can never be registered. Anybody could put the word donuts in their name. So that's definitely out. So if we're sitting down for the first time and you want to register something that's generic, soap or something, we got to say, look, this is clearly not registerable. The second level was descriptive. If it's just describing what it is, they won't even let you just file or get a descriptive mark registered. They'll put you on what's called a supplemental register. And then after you've like let's just say McDonald's hamburgers. McDonald's is just a descriptor of who owns it, the guy Joe McDonald's in hamburgers, right? When the first day it comes out, it's very descriptive and it's not strong. But after they sell a billion hamburgers to a billion different people, everybody knows what McDonald's is. It acquires distinctiveness over time and it becomes a trademark. And the third one is suggestive, and that's now Dunkin'. What are they suggesting that they're selling? They're selling donuts and coffee, but they don't use the word donuts anymore in their name. They just words the Dunkin'. So I say try to come up with something creative like the Dunkin'. Arbitrary is putting the name Apple on a computer. Apple is an arbitrary thing. It has nothing to do with computers. And then fanciful is putting 7 letters in the box and coming up with Zillow or Exxon, Xerox, just make up a name. Those are the stronger names. So right away when we talk on that first day, that to answer your question, we want to say, let's get away from generic and descriptive. Let's try to lean towards something that's creative and suggestive like Duncan. And and if you could come up with an arbitrary or a fanciful name, even better, because now you're distinctive, nobody else has it. Everybody wants to have those descriptive trademarks because that's what people are typing into their Google searches. But at the end of the day, you can't stop somebody from using the word donut. But I certainly can stop them from using the word Dunkin'. And it's a very, very, very strong mark right from the start. So why don't we start off strong, build your reputation, and make sure that you're the only one can use your trademark.
That's good. Good stuff. I'm gonna have to wrap it up and go get myself a donut. So we're out of time. Uh, thanks.
Hey, thanks, Sean. I really appreciate working with you. It's always fun going through these
Yeah,
scenarios with you.
yeah. Same here. Same here. And to everyone out there, thanks for listening to Guardians of Innovation with Vincent LoTempio. If you're trying to protect a trademark or trade dress, and you need to navigate that potentially fraught path, Vincent and his team can help and help you deal with the risks, long-term strategy, and really help guide you in a way that saves you a lot of frustration. You can visit lotempiolaw.com to learn more. And don't forget to like, subscribe, and leave a review if you like this episode. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.